We're in session in cause number 330-372 and cause number 330-568. Both cases are styled the state of Texas versus Christopher J. Stabler. Mr. Stabler, would you please come forward? Yes, I thought I had this. Oh, I put it wrong. You have some white out? Don't worry about it. I'll get some later. Mr. Stabler, you have before you a document that is titled Standard Bond Conditions in County Court Law Number 2. Do you see that document? You see the title of that document? It says Standard Bond Conditions in County Court at Law Number 2. You see that?
Right.
Okay, I'm gonna go over this document with you.
Okay.
And it reads, following the return of criminal information in County Court at Law Number 2, Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the following additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state or of the United States. Do you understand that condition?
Yes.
Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs or alcohol in the defendant's body, and that's pursuant to the Texas Code of Criminal Procedure, Article 17.44, Section A2 and Section C2. Do you understand that condition?
Not exactly. I'm confused as to what all this is about.
It's the standard. You're out on bond. Is that correct? There are conditions of bond, and I'm reading to you your conditions of bond. If you violate any one of those conditions, your bond can be revoked, and you could be placed in the Jefferson County Jail.
Okay. I thought that I had already got these the first time I got mailed out the conditions. It's okay.
I don't know. Maybe your bonds may have given you some conditions. I don't know.
All right. I've never done this before.
Okay, I
I've been
understand.
in trouble before.
Okay, so do you understand condition number 2, or should I read that again?
No, I understand it. Don't do
Okay.
stupid shit.
Okay. Well, that doesn't say that, and if you curse again in this courtroom, you're going to be held in contempt and you're going to be placed in the Jefferson County Jail. Do you understand?
Yes.
All right. That condition, I'm going to read that again. It says the defendant shall submit to testing for drugs and alcohol at any time directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body, and that's pursuant to the Texas Code of Criminal Procedure, Article 17.44, Section A2 and Section C2. Do you understand that condition?
Yes, sir.
Condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes.
Now, condition number 4 doesn't apply because that only applies in a DWI case. Your case is not a DWI case. And you turn to the next page, condition number 5. states that the defendant shall wear a global positioning monitoring system device at the defendant's expense with written verification being submitted to court within 3 days. Do you understand that condition?
I think I do.
All right. Now, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, that simply means that you could be placed in the Jefferson County Jail. Now, I think, has this case been reset? They told me you need your case reset to give you some more time to think over the offer.
I need,
This defendant would like some time to review the evidence.
Okay,
And so we do need to reset that.
okay, so what we're gonna do, we're gonna reset your 60 days. So that'll give you time to get with the district attorney's office to review or what we call discovery, to look at the state's evidence, okay? So give him a reset for 60 days, and,
and
okay,
what is that, does this reset 60 days? Like, I don't understand how this works.
okay. A reset for 60 days means that you're gonna come back to court in 60 days.
Okay, and
Your court date is gonna be in 60 days.
okay, and then how much do these global positioning things cost?
I don't know, you may have to call or Google and call and find out from the company that provides that service, and they can tell you, they can give you all that information. But I do not have that information with me.
Is the state willing to suspend that?
That's a condition of the court,
Is the court,
as a condition of bond. The court sets the bond conditions. Now, the state could object or
can
or
I
whatever.
request the positioning thing? Not because I'm strapped, I'm stretched so
no,
thin.
based on
just
what I
have-
read in the PC information, and what is the probable cause affidavit, that's why that condition was placed in there.
It's because I'm strapped for money.
No, it's because of the facts of the case, as it is alleged, the alleged facts of the case. Okay, but get your reset. You're gonna stand on that 4X, and the court coordinator will give you a reset. Your case is reset for 60 days, and you can have I guess you can set up an appointment with the district attorney to have discovery.
1 o'clock.
All right.
It's Mr. Jones, Stedman Jones, that wanted to consider the.
Oh, okay.
Yeah.
Yeah. Okay, that goes there. Jones.
It's at the end of the document.
The door on the left.
Oh, he didn't even sign this. Having to come back. He didn't even sign this waiver. Where is, Stedman, Jones. This way, Stedman, Jones. Edwards. And what, Denman? Did we have Denman's judge's explanation and waiver? We're in session in two cases. First case is cause number 330-578. Second case is cause number 330-580. Both cases are style of state of Texas versus Stedman Deshaun Jones. Mr. Jones, how are you doing?
All right,
That's good. Now, Mr. Jones, you're requesting that this case be reset so that you can consider the offer that the state has made to you. Is that correct?
yes.
Okay, how much time do you need? Well, let's do this here.
How
We're
much
gonna,
can you give? Because I
30
don't want to
days.
make the wrong decision.
okay, well, we're gonna give you 30 days.
Okay,
Okay, give him a reset for 30 days and don't put it on a arraignment docket. Put it on a docket for like Monday or a Friday.
Friday would be better.
Okay, see if you can get him a
Make that
Friday.
possible.
November 12th. Okay, Mr. Jones, your case is gonna be reset to November 12th of 2021. You can stand on the X in front of our court coordinator over there.
Will it be the same time or?
Yes, at 9 o'clock. It'll be on the paperwork that you're gonna get. Once you get your reset, you'll be free to go and you have a blessed day.
Thank you.
We're in session and cause number 321-838. Case is filed, the state of Texas versus Willie Lee Edwards. Mr. Edwards, would you please come forward? Your full name is Willie Lee Edwards,
Junior.
Junior? Okay. Mr. Edwards, would you please raise your right hand? Mr. Edwards, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Mr. Edwards, you may put your hand down. How are you doing, Mr. Edwards?
You?
I'm doing fine. Thanks for asking. Now, Mr. Edwards, you have a right to have a record made of this case. That is, you have a right to have a court reporter. As you can see, we do not have a court reporter here. Do you waive your right to a record?
Yes, sir.
Okay. Now, Mr. Edwards, I have before me a document that is titled Information. And in this information, it alleges that on or about October 14 of 2018, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of criminal trespass. Mr. Edwards, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Edwards, how do you plead? Guilty, not guilty, no
Guilty.
Guilty? Now, are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you're guilty?
Yes, sir.
Okay, Mr. Edwards, I have before me a document that is titled, the misdemeanor plea admonishment is also labeled as State's Exhibit Number 1. You recognize this document?
Yes, sir.
On page 2 of this same document, Mr. Edwards, there's a set of initials on a line next, with the initials of WE on a line next to a box that says check guilty. Are these your initials
Yes,
on this
sir.
line? And there's another set of initials below a paragraph that is titled discovery admonishment and the initials of WE, and it's on a line next to a box that says, I do not request discovery of evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty and no contest. Are these your initials on this document?
Yes, sir.
And on page 3 of the same document, there's a signature at the top of this document above the line that's titled Defendant. Is that your signature?
Yes, sir.
And on the next document, which is a trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
Is this your signature
Yes, sir.
on this document?
Yes, sir.
There are 2 boxes that are checked at the top of this document. The first box states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
Second box states that you're waiving, which means you're giving up your right to appeal. Do you understand that?
Yes, sir.
Now, Mr. Edwards, prior to signing and initialing these documents, did you have an opportunity to read the documents?
Yes, sir. I had left the paper over there.
Okay, and did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me State's Exhibit Number 1. State, you like to offer State's Exhibit Number 1?
Yes, Your Honor.
Mr. Edwards, I have before me State's Exhibit Number 1. State's Exhibit Number 1 is the first document that you acknowledge, that you recognize. And on page 2 of the same document is that you acknowledge that these were your initials. And on page 3 of this document, you acknowledge that this was your signature above the line that's titled Defendant. The state would like to use this document as evidence against you in this case. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
Okay, no objection. State's exhibit number 1 will be admitted. Mr. Edwards, is there any evidence that you're currently mentally incompetent to stand trial?
No, I don't stand no trial.
Oh, no. Listen to my question. Is there any evidence that you're currently mentally incompetent to stand trial?
No, sir.
Okay. Mr. Edwards, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. And I will also find that your plea and waivers were freely and voluntarily given. I'll also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
What is that agreement?
It's 30 days jail. Mr. Edwards has 30 days credit to time served, court costs to be taxed and retired.
Okay, Mr. Edwards. The state is offering that you serve 30 days in Jefferson County Jail. However, you will not have to serve any more time in the Jefferson County Jail because you've already served 30 days in Jefferson County Jail. Therefore, you'll be given credit for time served. The court cost in this case is $397, but you will not have to pay the court cost because the time that you spent in jail has already paid it off. Therefore, the court cost will be taxed and retired. Mr. Edwards, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Fair.
And do you accept the offer?
Yes, sir.
Okay, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Edwards, stand on the X right there in front of our court clerk. Once you, and follow her directions. Once you finish following her directions, you'll be free to go and you have a blessed day.
And Your Honor, he did have a warrant out, so I was gonna just make sure he's in mind that you need to make sure you get that. Paperwork.
Keep the judgment
Stay in
with
the
you.
system for a little bit.
Yeah, because it's take a few hours before it get out of the system. They're gonna put it in and then it goes through a process. And so keep the paperwork, which is in case if you get stopped, you can show on the paperwork that you have already taken care of this case because it has your case number on it. It's the same number that's on the warrant.
Okay.
All right? So once you finish in here, you'll be free to go and you have a blessed day.
Yes, sir.
You put your right thumb on the scanner there for me. Hold on. With that.
Nancy Denman.
Hold on to that, okay?
Thank you.
You're welcome. We're in session in cause number 329288. The case is styled the state of Texas versus Nancy Denman. Is that your full name?
Yes, sir.
How you doing, Ms. Denman?
Good, and you?
I'm doing fine, Ms. Denman. I have before me information that alleges that on or about March 8th of 2021, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of possession of a controlled substance. Ms. Denman, do you understand what you've been charged with?
Yes, sir.
And to this charge, Ms. Denman, how do you plead guilty? Not guilty, no contest.
Guilty.
Now, you're pleading guilty freely and voluntarily?
Freely.
And are you pleading guilty because you are guilty?
Being guilty.
Ms. Denman, I have before me a document that is titled the misdemeanor plea admonishment. It is also labeled as State's Exhibit number 1. Do you recognize this document?
Yes, sir.
On page 2 of the same document, Ms. Denman, there's a set of initials. The first set of initials is on a line next to a box that says check guilty. Did you place your initials here?
Yes, sir.
The second set of initials is on this lower paragraph that is titled discovery. It is on a line that states that I do not request discovery of the evidence in this case and I waive my right to discovery of evidence. And I enter a plea of guilty of no contest. Did you place your initials on this document? And on the next page of the same document, Ms. Denman, There's a signature above the line that's titled Defendant. Is that your signature? And on the next document, which is titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
Is this your signature above the line that's titled Defendant?
Yes, sir.
There are two boxes that are checked at the top of this document. The first box states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you're waiving your right to an appeal. Do you understand that?
Yes, sir.
State, I have before me State's Exhibit number 1. State, you like to offer State's Exhibit number 1?
Yes, Your Honor.
Ms. Denman, I have before me State's Exhibit number 1. And State's Exhibit number 1 is the first document that you acknowledge that you recognize. Is also the document that have your initials on page 2. And this document also has your initials on page 3, or your signature on page 3. The state would like to use this document as evidence against you in your case. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
Okay. No objection, State's Exhibit number 1 will be admitted. Ms. Denman, is there any evidence that you are currently mentally incompetent to stand trial?
Yes, sir.
Ms. Denman, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea of guilty and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
What is that agreement?
The agreement is for 10 days county jail with credit for time served, tax and retired court costs.
Okay, Ms. Denman, the state is offering that you serve 10 days in Jefferson County Jail. However, you're not have to serve any more time in Jefferson County Jail on this case because you've already served 10 days. The court cost in this case is $352, but you will not have to pay the court costs in the case of $352 because the time that you spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. Ms. Denman, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
I do.
And do you accept the state's offer? Okay, Ms. Denman, I will accept the plea bargain agreement that you have entered into with the state. Ms. Denman, please stand on the X and you're going to follow the directions of our clerk.
Thank you, sir.
Baby. What's the matter? Oh, I don't know. Where's, oh, here it is right here. Yeah, I didn't know. Yeah. Glad you said that. Here you go. And this is on Willie Edwards. This is- We're in session in cause number 323474. The case is styled the state of Texas versus Jacqueline Sevier Hill. Is that correct? Sevier Hill. How you doing, Ms. Hill?
I'm doing good.
That's good. Ms. Hill, would you please raise your right hand? Ms. Hill, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Okay, Ms. Hill, you may put your hand down. Ms. Hill, you're here represented by your attorney, Mr. Bruce Smith. Mr. Smith, how are you doing?
Fine, yeah, how are you?
I'm doing fine. Mr. Smith, do you waive a record in this case?
We do, yeah.
Okay, Ms. Hill, I have before me an information that alleges that on about March 15 of 2019, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of theft. Ms. Hill, do you understand what you've been charged with?
Yes.
And to this charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, are you pleading no contest freely and voluntarily?
Yeah, yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yeah, yes, sir.
Okay, Ms. Hill,
Mhm.
I have before me a document that is titled the misdemeanor plea admonishments. Do you recognize this document?
Yes, sir. I saw it.
On page 2 of the same document, Ms. Hill, there's a set of initials on the line next to a box that's checked NOLA contingent. Are these your initials on this document?
Yes, sir.
And on page 3 of the same document, there's a signature above the line that's titled Defendant. Is that your signature?
Yes, sir.
And on the next document, which is titled the Trial Court Certification of the Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
Is this your signature above the line that's titled Defendant?
Yes, sir.
There are 2 boxes that are checked at the top of this document. The first box check states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir. I do.
The second box states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes, sir. I do.
And Ms. Hill, I also have before me a document that is titled the Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature above the line that is titled Defendant?
Yes, sir.
Now, Ms. Hill, prior to signing and initialing these documents, Did your attorney, Mr. Smith, go over these documents with you?
Yeah,
And did you read and understand everything in this document, in these documents?
yeah, yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, now, hey, I have before me State's Exhibit number 1, the misdemeanor plea admonishments. State, you like to offer State's Exhibit number 1 and State's Exhibit number 2, the probable cause affidavit?
Yes, Your Honor.
Any objections? No objections. State's Exhibits 1 and 2 are admitted. Mr. Smith, you've advised and counseled Ms. Hill. Is there any evidence that she is currently mentally incompetent to stand trial?
No, there's not.
Ms. Hill,
I'm fine.
your attorney, Mr. Smith has advised and counseled you. Are you satisfied with his representation of you? Are you satisfied with your attorney representing you?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Okay, Ms. Hill, I will accept your plea of no contest. I will find that you are mentally competent to stand trial.
Mhm.
I would also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is that agreement?
1 year deferred adjudication. It's a no fine, 20 hours community service. And it's to run concurrently with cause number 14-18637.
Ms. Hill, the state is offering that you serve 1 year deferred adjudicated probation. During this deferred probationary period, you will not be required to pay a fine. However, you will be required to pay court costs
Hmm?
of $249. Let me ask you this here. She's currently on probation,
Yes, Your Honor, she is on Judge Stevens' probation.
and how long is that?
We're going back, the judge was talking about extending the probation. We're going back on the 19th, and she's going to continue on probation.
Okay,
8 years.
because the reason why I'm saying that is because there's $60 in this judgment. She won't have to pay that because if she's already on probation, she'll
Right.
be paying the $160, not the $260,
Right.
not 60 for each case. Do you understand that?
Thank you, Your Honor.
Okay. You also be required to pay a urinalysis fee of $15 each month. Now,
Who?
It's just,
these are just
No, I think-
conditions of your probation. Now, let me do this. It comes to a total monthly installments of $105. But as I said earlier, they're gonna subtract the $60 from this, so that'll leave $55, right? No, let's see, 60, 45. That'll be $45 that you would have to pay. However, if you're already paying a urinalysis fee of $15, they're gonna subtract another $15 from this. And so you'll be paying $30 a month
Okay.
probation fee.
What's the URA?
What do you,
Your
well,
analysis.
it's a urinalysis, yeah.
UA.
You know, so you,
That's
when you
right.
take a,
Oh, okay.
okay. So, what I'm saying is, when the probation officer see this judgment, probation officer know you on probation, you will not be required to pay. Now, if you're not on probation, then you're required to pay the $60.
Okay.
And if you're not already paying for urinalysis,
Mhm.
then you'll be required to pay for the urinalysis. Do you understand that?
Okay.
So right now, the judgment says $105, but if you're already on probation, they're gonna subtract the $60 probation fee out of here. And if
Okay.
you're already paying a urinalysis fee, they're gonna subtract the $15 from that,
Got it.
which means that it'll come down to about $30 a month. And will you be able to pay the monthly installments that you're required to pay? I'm not, on this here case, that's what I'm asking you.
So, yes.
Would you be able to pay $30 a month?
Yeah.
I mean, I'm just asking you, you can, if you cannot, just let me know.
Yes, sir.
You will? Okay, so you'll be able to pay the $30
How
a
much
month.
is it in total?
$30 a,
$30.
well, I don't, it's $30 each month. I don't, the total,
On top of that.
It's gonna be good.
Yes, sir.
so you'll be able to pay the $30. Okay. Now you'll also be required to pay, excuse me, to perform 20 hours of community service during this 1 year. You'll also be required, well, this case will run concurrent with cause number 14-18637. That's the probation case, the felony case. And as I said earlier, your fine is waived, and you would also be required to adhere to the other standard terms of condition of your probation. Do you understand that? All right. Now, Ms. Hill, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer? Okay, Ms. Hill, I'll follow, well, the court is going to defer a finding of guilt and place you on probation with the terms and conditions that you have agreed to in this case. Do you understand that? And now, Ms. Hill, if you successfully complete the probationary period, this case will be dismissed. It will not result in a conviction on your record, and you may qualify for a non-disclosure. You can talk to your attorney about the non-disclosure. He's quite competent in these matters. Now, Ms. Hill, you're gonna stand on the X where your attorney is standing. You're gonna follow the directions of our court clerk. Once you finish following her directions, you'll be free to go, and you have a blessed day. There you go.
Place your right thumb on the scanner for me. Okay, got it. Sign the pen cap. You won't be able to see it, but I can see it all. Here's a copy of the paperwork.
Oh. Yeah, that door is locked. You gotta go through the door you came in. Okay, the court is back in session in the court's arraignment docket, which was scheduled at 9 a.m. on this morning of October 12th of 2021 in County Court at Law Number 2, Judge Terrence L. Holmes presiding. Next case is cause number 330244, case of style of State of Texas versus Patrick Anthony Edwards. Mr. Patrick Edwards is scheduled to be in court this morning at 9 a.m. At or about 9 a.m., Patrick Edwards' name was called by the court's bailiff at the courthouse door. Patrick Edwards did not answer. Patrick Edwards has not been in court since the court's been in session. The time now is 12:30 p.m. Mr. Bailiff, would you please call the name of Patrick Edwards?
No response.
Patrick Edwards' name was just called by the court's bailiff. Patrick Edwards did not answer when his name was called at the courthouse door. A reasonable time has passed to give Mr. Edwards an opportunity to appear in court. He has not appeared in court. State, do you have a motion?
Yes, Your Honor, state would move for bond forfeiture.
A motion would be granted. In cause number 330244, Patrick Edwards' bond will be forfeited and a warrant shall be issued for his arrest. We are now in session in cause number 330280. State is the case is styled the State of Texas versus Clifton Bruce Rodriguez. Clifton Rodriguez was scheduled to be in court this morning, 9 a.m. And his name was called at or about 9 a.m. by the court's bailiff at the courthouse door. Clifton Rodriguez did not answer. Clifton Rodriguez has not appeared in court since the court's been in session. The time now is 12:32 p.m. on today's date. Mr. Bailiff, would you please call the name of Clifton Rodriguez?
No response.
Clifton Rodriguez's name was just called by the court's bailiff at the courthouse door. Clifton Rodriguez did not answer. A reasonable time has passed to give Mr. Rodriguez an opportunity to appear in court. He has not appeared in court. Therefore, State, do you have a motion?
Yes, Your Honor, the state would move for bond forfeiture.
That motion will be granted and warrant shall be issued for the arrest of Clifton Rodriguez. Ms. Jackson, did that conclude the docket? Did we include the name of the individual that called in? The individual that called in said he had,
Oh, yes, sir.
what was it? Was it
It was the last one.
Clifton Rodriguez? Okay. Now, this was conclude the calling of the court's arraignment docket was scheduled at 9 a.m. on today's date, October 12th, 2021, in County Court at Law Number 2 of Jefferson County, Texas. Judge Terrence L. Holmes presiding. Everyone, please have a blessed day.